You still want me to call that case, Judge?
Will it take you long to print out?
A few seconds. We can go on to Mr. Shawala's. Okay.
All right, let's go ahead and do that then.
Judge, is this one you want to hear? You may recall this is one that you had reset and you had said, well, I want Judge Pettis to hear this because it's a probation case.
I've talked to Judge Pettis, and so I'm okay with this.
Okay.
Okay.
Annex, may we have Benjamin Philowa?
To the one state, yes, sir. Yes, sir.
Ms. Elizalde, I do need to ask you though, technically, the other one got transferred from the 168th. It didn't make the official docket, but it is set today. Are you okay proceeding with this hearing?
I am, Judge. I recalled our previous conversation. You're not ready for it.
Good. I'm glad you remembered that. All right.
In cause number 2022-0D00647, State of Texas versus Benjamin Philowa. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Alex Shawala for Mr. Filia. We're ready.
All right, Mr. Marufo, please go ahead and call the case that has been transferred from the 168th also. Do you have that cause number?
Yes, Judge. And cause number 2022-0D05577, State of Texas versus Benjamin Philowa. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Alex Shawala for Mr. Filia. We're ready, Judge.
All right. So we had started this hearing last week, Mr. Shawala, and my understanding is Mr. Philowa is on probation for his robbery case, correct?
That's correct.
All right. And then what is the bond on that right now?
There is no bond set, Judge.
Okay.
It was a bench warrant.
Okay, that's what I remembered, but I wanted to be sure. And then the 5577, what is the charge on that one? My Odyssey Navigator is offline.
Assault on a public servant.
Assault on a public servant. And what is the bond on that one?
I don't have that right in front of me, Judge. I can look it up.
It's okay. Miss Catherine can give it to me. If she can.
I'm opening it now, Judge. Just 1 second.
All right, it's a 5,000 cash assurity according to Marisa Nieto from District Clerks. All right. All right, so Mr. Shawala, this is your motion, so let's go ahead and get started with you first.
Thank you, Judge. On both these cases, I would like the court to consider the facts as alleged. And I know you don't necessarily have all that information in front of you, but the first, and this is apparent if you're able to look at the complaint affidavit, this man should not be on probation for robbery. The case as a matter of law does not meet the elements of the offense. The allegation is that he took a drill. That was the only thing he took. Complainant confronts him. He throws the drill at him and runs away. And that's the assault for the robbery. Well, in order to commit robbery, you have to commit the assault with the intent to maintain control of the property. I would submit to you, it's pretty clear that if you throw the thing away that you're supposed to be stealing, you're not committing robbery. May have committed an assault, may have committed a theft or an attempted theft, but it just does not meet the elements. So I think this is a case that could be easily undone with a writ. If we get to the point of filing one, we may not need to get there. I think we may be able to work something out given the new allegations, but that is something worth considering, that I don't think the man should be on probation in the first place. In terms of the new case, Judge, I'm sure Ms. Elizalde will have a different perspective on this, but this is a case where, if the court had an opportunity to review the videos, and if you have an opportunity to look at the complaint and the statements by the officers, this was a beating. I mean, this man was beaten down by these officers. In fact, one of the officers fractured his hand punching my client in the face. The audio, you can't see the interaction on the video, but the audio is several minutes of my client screaming as he's being beaten. And then the allegation is that at some point in there, while he's being tased and punched and kicked, he one time kicks the officer in the leg, resulting in no injury I can see. So it's just, I think the facts are important in setting the bond. In terms of what he would do, let's see, he would be looking essentially for a place to stay. The place where this occurred, the assault on a public servant, is where he was staying before with a friend who lives there. Obviously, he's not welcome there by property management, so he may need to go to the opportunity center or something of that nature. But he has strong ties to the community, Judge. He's not going anywhere. He's been here since 2001. He's a U.S. citizen. And, we're not, given the nature of this and his criminal history, we're not asking for a PR bond or anything like that. But he can only put together, a few $100s. So, if we could get something to where he's looking at $4,000 to $5,000 total, he may be able to put a surety together, through friends. And so we're kind of looking to have his bond on the, as it's currently set now on the assault on a public servant, be the total amount. Once we add in whatever bond you set on the probation case. And then he has a misdemeanor resisting. I think the bond there is a couple thousand or something like that. So,
All right. If I remember correctly, he wasn't doing anything while he was on probation. And I know you want to go ahead and challenge the robbery conviction, but that's not for this moment or for this time. And I'm not sure who pled him on the robbery. And I'm not sure which route you would want to take if you were to challenge that. But again, it's not for this period of time. Now, I want to verify with Ms. Pineda from probation if my recollection of him not doing anything on probation is correct. Ms. Pineda?
Good afternoon, Judge. Yes, that is correct. Mr. Fillaway never reported to probation. And thereafter, that's when the rearrest in December of 2022 occurred.
Okay. So how long was he put on probation?
He was placed on probation, Judge, on August 30th, 2022.
So he did nothing all of August, September, October, November, and then he gets arrested in mid-December?
Yes.
And then he's been in jail since mid-December?
Yes.
All right. Okay, so that was my concern, is that several months had occurred and he didn't report, Mr. Shawala. I understand that you claim his ties are strong, but he wasn't strong enough to be reporting to probation during that time. Let me ask Ms. Elizalde her position really fast before I make a final decision.
Yes, Judge, the state would oppose to a bond reduction.
Well, it's a bond setting actually, because it's a zero bond. So I do need to go ahead and set something, but go ahead and tell me.
Let me go ahead and change that and say the state would ask for a bond that reflects the fact that he is a flight risk. He was not reporting that he is a danger to the community. Further, he is habitualized. He's got 2 separate pen trips. So he's looking at a minimum at 25. I have put up a rec. The current rec is 3 TDC. And a lot has been said about the facts of this case, but I submit to this court that none of this would have happened if he wasn't trying to escape and resist. And when officers found him in the room, he was holding a clear and colored pipe in his right hand. He has demonstrated to this court that he will not report, that he will not listen to bond conditions. And so we think that the bond should reflect that, Your Honor.
All right. And have you already given notice of your enhancement or habitualization? I forgot what you said, if you said enhancement or habitualization.
I'm not sure that he's enhanced by indictment, but I might have to file a notice, Judge. I don't think I filed it yet.
Okay.
I'm certainly aware of his history, Judge. So
Okay. All right. Well, so then it can't be a surprise to you that the bond is still going to be pretty high, Mr. Shawala. I'm going to go ahead and do a split bond. It's going to be 100. And I'm gonna do 70 cash surety, 30 PR. During that 30 PR, I need monthly, actually, you know what, with him right now, if he does get out, I want weekly reporting to the PR bond, weekly. No contact with any of the complaining witnesses in the robbery. Of course, contact as to where he'll be. So it's 100,000, I'm splitting it, 70 cash surety, 30 PR. Does everybody have that? Miss Catherine, did you get it?
Yes, Judge, I got it. Thank you.
All right, Mr. Shawala, is there anything further?
Let them to repeat it.
No, Judge, if I can find out real quick, Ms. Elizalde, when would be a good time for me to call you? Because I think we can work something out here.
Okay, I believe I have your email. Let me go ahead. I'll send you an email with my personal cell and go from there. Okay?
Okay, sounds good.
Your Honor, this is Joe Annex. The system just froze. I had to log off and log back on. The enemy wants to know what the outcome was, please.
Okay, I gave a split bond. It's a total of 100. 70 is cash surety, 30 is PR, and I gave conditions well on that PR bond if he were to get out.
Thank you very much, Your Honor.
Okay, that's going to be on only the cause number of 00647. I'm going to leave the 557 as the 5,000 that it was when you began this hearing, Mr. Shawala.
I understand, Judge.
All right,
Thank you. I think that's all I have today. May I be excused?
you may be excused. It was good to see you, Mr. Shawala. Take care.
Likewise.
Bye-bye.
Bye-bye.
Annex, we have Avila, Jose Avila.
Avila. Avila.
In cause number 2018-0D04860, State of Texas versus Jose Avila. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Melissa Warwick on behalf of Mr. Avila, we are ready, Your Honor.
All right. And as it is a bond hearing, I'm assuming it is your motion, Ms. Warwick, so go ahead and begin.
Thank you, Your Honor. Mr. Avila has been in custody for quite some time now. He is in custody on a probation revocation. However, as of today, I do not believe a motion to adjudicate has actually been filed. He's on 5 years of deferred adjudication. Part of the problem we have here is, Your Honor, is he has diagnosed mental health conditions and he is not receiving his medications in the jail. And that's part of the issue with him remaining in custody. He is not getting the mental health treatment that he needs. And Your Honor, he is on deferred probation, so he is legally entitled to a bond. Last time I checked, no bond was set. I'm asking if the court can please set a reasonable bond, taking into consideration his mental health needs and the fact that he is on deferred probation. Your Honor, I did speak to his probation officer, Betsy Dominguez, and my understanding is that the current recommendation from the probation department is for him to continue on deferred probation with outpatient treatment. He was doing TAP, but some issues arose. He did test positive in November for methamphetamine. He failed to report and he missed UAs in March and April of 2022, I believe. And he does have a substance abuse issue, which is why the recommendation is to continue with outpatient treatment. So again, we would ask the court to set a reasonable bond in this matter. And again, emphasize that a motion hasn't even been filed.
Ms. Elizalde, can you give me a status on your all's position?
Yes, Judge. I would again say that I don't believe that. I guess what I say is, I do believe that the defendant should stay in to get help. I'm a little bit surprised that the probation department is requesting outpatient treatment, given the entire history before them. The motion to adjudicate that has been drafted and is going to be filed.
Okay.
I have looked at this. He's done BHRTC, completed that successfully, but we keep going back and forth. I'm kind of at the point where I'm thinking of safe P as a possible alternative, but And here's the thing, I don't know, the recommendation from the department says, Counselor, Mr. Avila to be assessed by TAP while in custody.
Correct.
So how is it that they're recommending outpatient when they haven't even completed the TAP that they're requesting being in custody? Maybe there's a mistake there.
Well, let me go ahead and ask Ms. Pineda, because my understanding is there was supposed to be a TAP recommendation. Ms. Pineda, do you know anything about the TAP recommendation?
Your Honor, I believe what I'm getting from the probation officer's report is that they're trying to get an evaluation through TAP while he's still in custody. So TAP is still pending. It hasn't been done.
When did we ask for the TAP recommendation?
It hasn't. Let me check. I don't know the date. Let me see.
And then isn't Project Chance working the MHMR caseload from while they are in jail?
Are you asking me, Judge?
I'm sorry, say that again?
Are you asking me?
Yes, I'm asking you.
I'm not aware of that, Judge.
Okay.
Your
My-
Honor,
Go ahead.
I spoke with Ms. Dominguez back on January 13th, and she told me that she anticipated Mr. Avila being evaluated within 2 weeks of that date, but I visited him the week before last and he still had not been evaluated. So I could tell you, at least as of January 13th, that's what we were advised by the probation department.
Judge, if I may,
Go ahead.
there was an email response to Judge Perez earlier this morning. The TAP appointment was supposed to be today at 2 p.m. I am not sure if anybody spoke to Mr. Avila, but I can double check.
Ms. Warwick, I'm going to ask him if he was seen today. Okay.
Understand.
Mr. Avila, have you been able to hear what's been going on?
Yes, ma'am.
All right. Were you seen today at 2 p.m.?
No, I wasn't. It's around the time I came over here.
Okay. All right.
It could have been this bond hearing that,
I don't know. He needed to be seen. And he needs services while he's in there. All right, Ms. Warwick,
Judge, if I may.
yes, go ahead.
Just to remind the court, I understand that the probation department, that's where the recommendation for him to get a new evaluation. However, just to let the court know and everybody, Mr. Avila was at one point in BHRTC, then he's been referred to different outpatient programs for treatment. He is currently under the mental health caseload. There is notation here, back in December, he was missing appointments with EHN. He was missing doctor's appointments. So, he has been referred and was getting some kind of assistance. I think at this point, it's just trying to see what level of treatment he needs.
Okay, so that's the thing, Ms. Warwick. I'm concerned about if he were released, exactly what the circumstances are for watching him and helping him. Well, I know the jail is not moving at a speed that and I don't mean the jail, I mean the evaluation through MHMR. I'm not trying to criticize the actual jail, but he needs to be evaluated. So Ms. Pineda, I need an evaluation yesterday. Okay.
And this is for TAP.
It's both. He hasn't been evaluated for MHMR services through the jail. The name that I'm familiar with is B. Avila. I know she works through Emergence, I believe. We need to see if he was on meds, that his meds are continuing. I'm not comfortable based on my visual right now of releasing him. I'm going to set a bond so that at least there is a number. But Ms. Warwick, you're going to understand that it's obviously not going to be a very low number.
Understood.
I want him seeing Ms. Pineda. I want him seen. I don't know if you write directly to be Avila. I don't know if you contact your MHMR. I'm not seeing if meds are being administered right now. And I don't want him released in the condition that I'm seeing him in right now. All right. So I'm gonna go ahead and set $120,000 bond. I'm gonna split that. It's gonna be 70 cash surety, 50 PR. I understand that this may not have been what you wanted, Ms. Warwick, but I'm also not comfortable with what has transpired with the lack of services. Ms. Pineda, please make this a top priority.
Your Honor, if I may, he is linked to EHN services.
He is linked.
Yes, he is, Judge, because he is under, right now on probation, he is under the
MHMR caseload.
MHI caseload. So in
Right.
order to be in that, that means he's.
So has somebody seen him in the jail? Has somebody made sure that meds are being given? Has somebody reached out to where he's living, any type of social services in addition to that?
I can ask his probation officer to see if whichever caseworker through EHN.
Well, and that's what Ms. Warwick said,
done
that
that.
she had spoken to Ms. Dominguez back in mid-January. And Ms. Dominguez had said he was going to be evaluated within a week. And as of today, he still has not been evaluated.
The evaluation.
Ms. Warwick, did I misstate anything?
Your Honor, she told me within 2 weeks, but yes, that is correct.
So that's the thing. So speak to Ms. Dominguez. Let us make sure that he's getting what he needs before we're looking at lowering this bond by anything, okay?
Okay.
All right. Ms. Elizalde, I would make sure that motion to adjudicate is filed before the end of the day, but that would be your call.
Yes, Judge, we're working on it.
All right. All right. Ms. Warwick, anything further from your side?
No, Your Honor, thank you.
All right. Thank you. Good luck, Ms. Warwick.
Thank you, Your Honor.
Take care.
Thanks.
Annex, may we have Jasmine Valenzuela? On page,
Mira, Your Honor.
on page 21, Judge.
Valenzuela. She's over here. The female.
All right. Whenever you're ready to call the case, Mr. Marufo, that's fine.
Yes, Judge. In cause number 2022-0D02654 and 2022-0D01179, State of Texas versus Jasmine Valenzuela. Announcement of council, please.
And Liana Elizalde for the state. State is ready.
Edward Hernandez, Deputy Public Defender with the Mental Health Unit, on behalf of Jasmine Valenzuela. We're ready to proceed, Your Honor.
All right. Let me go ahead and have Ms. Valenzuela raise her right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, Ms. Valenzuela?
Yes, Your Honor.
All right. Go ahead and lower your right hand. Ms. Valenzuela, please state your full name, date of birth, and whether or not you are a U.S. citizen.
My name is Valenzuela Jasmine. Date of birth 11/24/91. Yes, I am a U.S. citizen.
All right. Ms. Valenzuela, as you stand there right now, I'm showing that you are charged with 2 offenses, both of them possession of a controlled substance. One of them will be reduced to a misdemeanor, is my understanding?
That's correct, Your Honor. 1244B.
All right. And so the punishment for that state jail is not more than 2 years and less than 180 days. And for the misdemeanor, it's not to exceed 1 year in the El Paso County Jail or a fine not to exceed $4,000. The state jail is not to exceed $10,000 fine. Do you understand these charges?
Yes, ma'am.
All right. Understand that as you stand there, you have the right to remain silent, a right to trial by jury, a right to counsel, a right to confront or cross-examine witnesses, a right to call witnesses on your behalf or in your defense. Do you understand these rights?
Yes, ma'am.
All right. Mr. Hernandez, have you had more than 10 days to prepare for the defense in this case?
I have, Your Honor.
All right, and Ms. Valenzuela, I have before me what's been marked as State's Exhibit 1, which are the plea packets. Is it your signature on these cases?
Yes, Your Honor.
All right, and let me go back real fast. Ms. Valenzuela, are you okay with waiving your presence in a courtroom and having this hearing done via teleconference / Zoom?
Zoom is fine.
Okay, we will continue then. So it's your signature. Did you read and understand the plea papers?
Yes, ma'am.
Right, Mr. Hernandez, did you explain the plea papers to your client, and do you believe she has an understanding of the admonishments, the rights, and the consequence of giving up these rights by entering a plea in these cases?
Your Honor, I met with my client on numerous occasions. I went through the paperwork with her. She signed it in my presence. I do believe she understands what she's doing, what the consequences are, what the admonishments are.
Ms. Valenzuela, are you satisfied with your attorney's representation of you in this case?
Yes, ma'am.
All right. And Mr. Hernandez, do you have any reason to believe your client is not presently competent to enter into this plea?
Your Honor, while my client is a client of the mental health unit of the public defender's office, I've met with her a number of times, and right now believe her to be competent and see no indications that she's not.
All right, Ms. Valenzuela, have you ever been found incompetent by a court or examined by a doctor or psychiatrist who has found you to be mentally ill?
I have in 2018.
Okay,
Oh, wow.
and right now, do you understand everything that's going on?
Yes. Your
All
Honor.
right, and you understand what my role is as a judge?
Yes, ma'am.
And
Yes,
you
ma'am.
understand, and you understand what Ms. Elizalde is here for as the prosecutor?
Yes.
Okay, and you know who is your attorney?
Yes. Yes, ma'am.
Okay, who is it?
Hernandez.
Okay, and he is helping you in this case?
Yes, ma'am.
All right, so you understand everything that's going on?
Yes, ma'am.
All right, based on your statements, based on your attorney's representation and based on my observations and the answers to my question, I'm going to find that you are competent to enter into this plea. You stated that you are a U.S. citizen, and I want you to know that I do believe you, but just in case for any reason you are not, understand that a plea of guilty and a finding of guilty may result in deportation, the exclusion from admission to this country, or the denial of naturalization. Do you understand that?
Yes, Your Honor.
All right. So now that we've taken care of the citizenship and the competency, let me ask you, to the charge against you, to the two charges against you, what is your plea?
I plead guilty.
In both counts?
Yes, ma'am.
All right. And are you making this plea freely and voluntarily?
I plead it.
Say it again. I couldn't hear you.
Yes, ma'am.
All right. So let me go ahead and ask the state, please summarize the evidence, Ms. Elizalde.
Yes, Judge, as to cause number ending in 2654, had the state proceeded to trial, the state would have been able to prove beyond reasonable doubt that on or about the 19th day of May 2022, the defendant, Jasmine Valenzuela, hereinafter referred to as defendant, did then and there intentionally and knowingly possess a controlled substance, namely methamphetamine, including adulterants or dilutants, in the amount of 1 gram or more, but less than 4 grams. At this point, we would ask that the court introduce into the record States Exhibit 1 and 2, plea papers, and 39.14 disclosure.
What was the controlled substance, Ms. Elizalde?
Methamphetamine.
Okay.
May I respond, Your Honor?
Yes, go ahead, Mr. Hernandez.
Just to clarify that my client is pleading to under 1 gram, possession under 1 gram. It's a lesser included state jail sentence.
On the 2654, I'm not showing it's a lesser, I'm showing it was charged as a state jail.
It is a lesser, Judge. It's charged as an F3 and it's a lesser included state jail felony. So it's
That's why they were saying 1.79 grams, Your Honor, but the agreement is under 1 gram.
Okay, so let me. Give me 1 second. All right, I'm gonna go ahead and show that on 2654, she is pleading to a lesser included offense. Okay, there was no lesser within the plea paperwork.
Thank you, Your Honor.
All right, go ahead on your, in regards to the paperwork, Mr. Hernandez, any objection?
No objection, Your Honor.
All right, going on to 1179.
Thank you, Your Honor. How we proceeded to trial. We have been approved that on or about the 13th day of October 2020, Jasmine Valenzuela, hereinafter referred as defendant, did then and there intentionally or knowingly possess a controlled substance, namely methamphetamine, having aggregate weight, including adulterants or dilutants, in the amount of less than 1 gram. Again, Your Honor, we'd ask that you introduce into the record States Exhibit 1 and 2 plea papers and 39.14 disclosure form.
Okay, before I ask Mr. Hernandez, this is the one that I am showing is being reduced to a lesser. I'm showing you
This one's a 1244B, Your Honor.
correct. So it's going to be punished as a
Misdemeanor, Your Honor.
All right, Ms. Elizalde, is that correct on your end?
That's correct, Your Honor, and both are 6 months to run concurrently.
And if I may add, Your Honor, there was also an agreement that my client would plea to 3 misdemeanors, and she pleaded to all 3 on Friday, Your Honor,
All right, so she's gonna be getting 6 months,
across the board.
okay, in which facility?
That'll be,
Time served already, Your Honor.
Oh, okay. All right, so then let me go ahead and as to the paperwork, Mr. Hernandez, on the clause number 1179.
No objection, Your Honor.
All right. All right, so let's go ahead and for the record, it's been mentioned, but Ms. Elizalde, what is the plea agreement?
Your Honor, on the cause number ending in 2654, that's going to be a lesser included state jail felony, 6 months. And on cause number ending in 1179, that's going to be a reduction 12.44B, 180 days in jail.
All right, so Ms. Valenzuela, is this your understanding of the plea agreement?
Yes, ma'am.
All right, Mr. Hernandez, have you had a chance to review portal and all documents tendered to you?
I have, Your Honor.
And is this your understanding of the plea agreement in this case?
It is, Your Honor.
All right. Ms. Valenzuela, understand the plea agreement is not binding on the court. However, should I reject it, I would permit you to withdraw your plea of guilty. If the court follows the plea agreement, you may not appeal this case except on matters raised by written motion or filed except on matters raised by written motion and ruled on before trial or by permission of the court. These are the appeal rights as explained in the trial court certification of your right to appeal, the original of which was signed by you, your lawyer, and by Judge Bettis, and a copy of which will be provided to you at a later time. Based on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I'm going to go ahead and sentence you. I find you guilty in 2654 of the possession of a controlled substance under a gram, and I assess your punishment at 6 months in the Texas Department of Corrections State Jail Division. That is in 2654. And in 1179, I find you guilty of the possession of a controlled substance reduced to a misdemeanor 1244B. I assess your punishment at 180 days in the Texas Department, in the El Paso County Detention Facility. Again, 180 days in the El Paso County Detention Facility. Your sentence will commence this day and you'll be given credit for all time that you have spent in jail on these charges. Mr. Hernandez, have I followed the recommendation?
I believe you have, Your Honor.
All right, Ms. Elizalde, have I followed the recommendation?
You have, Your Honor.
All right, anything else from the state?
Nothing further.
All right, anything else from defense?
Nothing further, Your Honor.
All right, that concludes this matter. Ms. Valenzuela, good luck to you. I hope this is the last time you're in the criminal justice system, and I wish you the best. Take care.
Thank you.
Bye-bye.
Am I excused, Your Honor?
And Mr. Hernandez, if you have nothing further, you are excused.
Thank
Mr.
you.
Maruco, who's next?
Mr. Brown on page 19, Judge.
All right, I'm ready.
Annex, may we have Mr. Brown, Melvin?
Coming out.
Who's going to be the public defender on this one?
Mr. Rick Hoffman. Judge.
Good afternoon, Judge.
Good afternoon, Mr. Huffman.
Very
There
well.
you are. Nice to see you, Mr. Huffman.
You too, Your Honor.
All right. All right. And then who is M. Hernandez and Deborah Ebavan?
Ms. Myrna? Judge?
Myrna, okay. And then Deborah Ebavan?
That's,
The supervisor, Judge.
Okay. The supervisor of,
he's my backup judge.
oh, she's your backup? Okay. All right.
In cause number 20? Excuse me. 2022-0D04962, State of Texas versus Melvin Brown. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Rick Huffman on behalf of Mr. Brown, we are ready.
All right, Mr. Brown, let me go ahead and ask you, first of all, are you okay waiving an in-court, in-person hearing to proceed with a plea via teleconference/Zoom?
Yes, ma'am.
All right, so with that being said, let me have you raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you may lower your hand. Let me ask you to state your name, date of birth, and whether or not you are a U.S. citizen.
My name is Robert Brown. My date of birth is 2/4/1974. I'm a United States citizen.
All right, Mr. Brown, currently charged with possession of controlled substance, penalty group 1, under 1 gram. The offense is a state jail, punishable by confinement not to exceed 1. Oh, they're going to reduce it to a 1244A for confinement not to exceed 1 year in the county jail and a fine not to exceed $4,000. Do you understand the charges against you?
Yes, ma'am.
All right. Mr. Brown, you currently have the right to remain silent, a right to trial by jury, a right to counsel, a right to confront or cross-examine witnesses, and a right to call witnesses on your behalf or in your defense. Do you understand these rights?
Yes, ma'am.
All right. Mr. Huffman, have you had more than 10 days to prepare for your defense in this case?
Yes, Your Honor.
All right. And Mr. Brown, I've been handed what's been marked as State's Exhibit 1, which are the plea packets in this case. Is this your signature on these cases?
Yes, ma'am.
Okay. And did you read and understand the plea papers when you signed them?
Yes, ma'am.
Mr. Huffman, did you explain the plea papers to your client, and do you believe he has understood the admonishments, the rights and consequences of giving up these rights by entering a plea in this case?
I did explain the plea papers, and I do believe he understands his rights and the waiver of his rights, Your Honor.
All right. Mr. Brown, are you satisfied with your attorney's representation of you in this case?
Yes, ma'am.
Mr. Huffman, do you have any reason to believe your client is not presently competent to enter into this plea?
No, Your Honor.
Mr. Brown, have you ever been found incompetent by a court or examined by a doctor or psychiatrist who has found you to be mentally ill?
No, ma'am.
All right. Based on your testimony, your attorney's representation, and my observation, the court finds that you are competent to enter into this plea. You previously stated you are a U.S. citizen, and while I do believe you, I need you to know that if you aren't for any reason, a plea of guilty and a finding of guilt may result in deportation, the exclusion from admission to this country, or the denial of naturalization. Do you understand that, Mr. Brown?
Yes, ma'am.
All right. Now that we've taken care of competency and citizenship, let me ask you, to the charge against you, what is your plea?
Guilty, Your Honor.
All right. Are you making this plea freely and voluntarily?
Yes.
I couldn't hear you.
I said yes, ma'am.
Okay, thank you. All right. Ms. Elizalde, let me go ahead and have you summarize the evidence, please.
Thank you, Judge. Had the state proceeded to trial, we would have been able to prove beyond a reasonable doubt that on or about the 8th day of September 22, in the county of El Paso and state of Texas, Melvin Brown, hereinafter referred to as defendant, did then and there intentionally or knowingly possess a controlled substance, namely methamphetamine, having an aggregate weight, including adulterants or dilutants, in the amount of less than 1 gram. There are 2 enhancement paragraphs that we are abandoning, so I'm not going to read those into the record unless the court desires otherwise. And at this point, we would ask the court to introduce into the record State's Exhibit 1, which is the plea papers, and State's Exhibit 2, the 39.14 disclosure form.
Mr. Huffman, what is
No
your
objection.
position at?
I'm sorry, Judge. No objection, Your Honor.
All right, said documents are admitted. Ms. Elizalde, what is the recommendation?
Judge, the recommendation is a 12.44A, 130 days.
All right. Mr. Brown, is this your understanding of the plea agreement in the case?
Yes, ma'am.
All right, and Mr. Huffman, is this your understanding of the plea agreement in this case?
Yes, it is, Your Honor.
All right, and have you had a chance to review portal and all documents tendered to you?
Yes, I have.
All right. Mr. Brown, understand the plea agreement is not binding on this court. However, should I reject it, I would permit you to withdraw your plea of guilty. If the court follows the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. These are the appeal rights explained in the trial court certification of your right to appeal. The original, which is signed by you, your lawyer, and by Judge Bettis, and it'll be given to you at a later date. All right. So based on your plea of guilty and the evidence introduced, I will accept your plea at this time and find the evidence substantiates your guilt. I'm going to go ahead and sentence you to, first of all, I'll find you guilty of the offense of possession of a controlled substance under 1 gram under 1244A. I assess your punishment at 130 days in the El Paso County Detention Facility. Your sentence will commence this day and you will be given credit for any time you have spent in jail on these charges. Mr. Huffman, have I followed the plea agreement?
Yes, Your Honor.
Ms. Elizalde, have I followed the plea agreement?
Yes.
All right. Mr. Brown, you'll go ahead and be fingerprinted in just a little bit. And paperwork will be given to you about this plea. All right, Mr. Brown?
Yes, ma'am. Does that mean that I received time credit for something already been in jail, right?
I'm showing 156. I'm showing the plea paperwork is 130. My guess is that you have completed your time. I'm always hesitant to promise things that I don't control considering the time of the jail, but I do believe you have finished your time, Mr. Brown.
Yes, ma'am. Thank you.
All right, good luck, Mr. Brown.
Yes, ma'am.
Take care. Bye-bye.
Next one is on page 20, Judge.
You know
Annex,
Hold on, Mr. Brown? Mr. Brown?
Coming back here.
Okay.
Yes, ma'am.
Mr. Brown, there is a parole hold on you, okay? I was just informed by the district clerk, okay?
Yes, I do understand.
I'm sorry, say that again?
I said, I do understand that.
Okay, I just wanted you to know that, so if you're not released, know that there is a hold on you. The
Yes,
district
ma'am.
clerk has informed me. Good luck, Mr. Brown. Good luck. All right. Okay, I'm sorry, Mr. Huffman, do you have anything further with me?
No, Your Honor.
All right, you are free to head
Oh,
out.
I'm sorry, yes, Judge, I do.
Oh, you do? Okay, Mr. Marufo, do you want to take care of Mr. Huffman or who's next?
yes, the rest of the cases are with Mr. Huffman, Judge.
What about Anthony Gonzalez?
He's received 1 week, Judge,
Oh, when did that happen?
right now.
Oh, okay. All right,
Annex, may we have Hicks? Miguel Hicks?
Coming up. Hicks? Yeah. Yes.
And Judge, I guess, Ms. Elizalde, one of these cases is getting dismissed.
I'm working on the motion.
Okay, just wanted to throw that out there.
In cause number 2022 0D0 5113 and 2022 0D0 4622, State of Texas versus Miguel Hicks. Announcement of council, please.
And Elizalde for the state. State is ready.
Rick Huffman, on behalf of Mr. Hicks, we are ready.
all right. Mr. Hicks, before I begin, let me ask you, are you willing to waive your in-person courtroom hearing in exchange for this plea via telecommunications / Zoom?
Yes, ma'am.
All right, so then we're going to go ahead and proceed. Please raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
All right, you may lower your hand. Let me ask you to go ahead and please state your name, date of birth, and whether or not you are a U.S. citizen for the record.
Miguel Hicks, date of birth 7/13 of 1982, and I am a U.S. citizen.
All right, Mr. Hicks, I'm showing that you are currently charged with a 3rd-degree felony that's punishable by anywhere from no less than 2 years, no more than 10 in the Texas Department of Criminal Justice, as well as a fine not to exceed $10,000. Do you understand that charges?
Yes, ma'am.
All right. Mr. Hicks, you understand you have the right to remain silent, a right to trial by jury, a right to counsel, a right to confront or cross-examine witnesses, and a right to call witnesses on your behalf or in your defense.
Yes, ma'am.
All right. Mr. Huffman, have you had more than 10 days to prepare for your defense in this case?
Yes, Your Honor.
All right. Mr. Hicks, what I've been handed what's been marked as State's Exhibit 1, which has a plea packet. Is this your signature on these papers?
Yes, ma'am.
All right. Did you read and understand the plea papers?
Yes, ma'am.
All right. Mr. Huffman, did you explain the plea papers to your client, and does he understand the admonishments, the rights and consequence of giving up these rights by entering a plea in this case?
I did explain to him the plea papers, and I do believe he understands the plea papers, Judge.
Mr. Hicks, are you satisfied with your attorney's representation of you in this case?
Yes, ma'am.
Mr. Huffman, do you have any reason to believe your client is not presently competent to enter into this plea?
No, I don't, Your Honor.
Mr. Hicks, have you ever been found incompetent by a court or examined by a doctor or psychiatrist who has found you to be mentally ill?
Yes, ma'am.
Okay, when was that, Mr. Hicks?
I was actually in the psych center. How long ago was it? A couple of years ago, right before I got incarcerated again.
Okay, I'm showing you've only been in jail about 121 days. Are you saying right before this you were?
No, not right before this one, right before my last incarceration.
Okay, so let's go back in time just a little bit. COVID started in 2020. Were you evaluated before then or after? COVID?
Before COVID.
Okay, so prior to March of 2020, you were found incompetent at one point?
Yes.
All right,
I went to the psych center, so I was in the psych center for a little bit.
all right. And when were you released from the psych center?
Like a month later,
All right.
like I just did like 30 days.
Are
I
you
don't
currently,
recall.
are you currently under the observation of any psychiatrist or are you a patient of a psychiatrist currently right now?
Right now I'm on medication.
Okay, and who prescribed that medication?
The psych doctor
Psych
here in the annex.
All right, are you understanding everything that's going on, Mr. Hicks?
Yes, ma'am.
Do you understand who I am and what I'm doing here?
Yes, ma'am.
Who am I?
You're the judge.
Okay, and what's my role here?
To give me the sentence that I signed for.
All right, and do you know who Ms. Elizalde is? Do you know who the prosecutor is?
Yes, ma'am.
Okay, and what's her job here?
The district attorney.
Uh-huh, very well, very good. And do you know what her role is?
I guess to sentence me.
Okay, pretty good. All right, and then who's your attorney? Who's here to help you?
Rick Huffman.
All right, and has he been doing a good job for you?
Yes, ma'am, he has.
All right, and you understand that you're pleading guilty today? Do you understand that you're scheduled to plead guilty today?
Yes, ma'am.
All right, and you're okay going forward with this?
Yes, ma'am.
All right. Based on your testimony, your attorney's representation, and my observation, the court finds that you are competent to enter into this plea. You previously stated you are a U.S. citizen, and I need you to know that I do believe you. But if for some reason you are not, a plea of guilty and a finding of guilty may result in deportation, the exclusion from admission to this country, or the denial of naturalization. Do you understand that?
Yes, ma'am.
All right. With that being taken care of, to the charge against you, what is your plea, Mr. Hicks?
Guilty.
All right. And are you making this plea freely and voluntarily?
Yes, ma'am.
All right. State, please summarize the evidence.
Yes, Judge, as to cause number 4622, had the state proceeded to trial, the state would have been able to prove beyond a reasonable doubt that on or about the 13th day of October 2022, in the county of El Paso and state of Texas, Miguel Hicks, hereinafter referred to as defendant, did then and there intentionally or knowingly possess a controlled substance, namely methamphetamine, having an aggregate weight, including adulterants or dilutants, in the amount of 1 gram or more, but less than 4. There are 2 enhancement paragraphs that we are waiving and abandoning, so I will not be reading those into the record. At this point, I would ask that the court introduce into the record States Exhibit 1, which is plea papers, and States Exhibit 2, 39.14 disclosure.
No objection from the defense, Your Honor.
Okay, these papers are now admitted. Ms. Elizalde, is there a recommendation?
Yes, Your Honor. The recommendation is 3 years confinement in the Texas Department of Criminal Justice with no period of community supervision. And we will also be dismissing cause number 2022-0D05113, and I'll follow up with the motion after this hearing.
When you email that, will you email that to Marisa, to the district clerk Marisa, please?
Yes.
Thank you. All right. Let me ask you, Mr. Hicks, is this your understanding of the plea agreement in this case?
Yes, ma'am.
Okay. Mr. Huffman, is this your understanding of the plea agreement in this case?
Yes, Your Honor.
And have you had a chance to review portal and all documents tendered to you?
Yes, Your Honor.
All right. Mr. Hicks, understand the plea agreement is not binding on the court. However, should I reject it, I would permit you to withdraw your plea of guilty. If the court follows the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. These are the appeal rights explained in the trial court certification of your right to appeal. The original of which is signed by you, your lawyer, and by Judge Bettis, and a copy of which is being provided to you at a later time. Based on your plea of guilty and the evidence introduced, I will accept your plea and at this time find that the evidence substantiates your guilt. I'm going to go ahead and find you guilty of the third-degree offense of possession of a controlled substance over 1 gram under 4. All enhancement paragraphs are abandoned. And under this, with the conviction on the 3rd degree, I assess your punishment at 3 years in the institutional division of the Texas Department of Criminal Justice. Your sentence will commence this day and you will be given credit for any time you have spent in jail on these charges. Mr. Huffman, have I followed the plea agreement?
Yes, Your Honor.
Ms. Elizalde, have I followed the plea agreement?
You have, Your Honor.
All right. Is there anything further from the defense?
No, Your Honor.
Anything further from the state?
No, Your Honor.
All right, Mr. Hicks, in just a few minutes, you will be fingerprinted, and they'll give you copies of some of your paperwork, okay? Mr.
Okay.
Hicks, I wish you safety in the next 3 years. Good luck while you're there. I know you're getting credit for at least what I'm showing 121 days. Okay? All right, thank you so much. We are adjourned.
Real quick question for Mr. Huffman. Is it gonna be running concurrent, Mr. Huffman, like we talked about?
Okay. So, Mr. Hicks, that's gonna be up to the parole board. It's their discretion. It's at their discretion.
Okay,
But they can.
okay.
Okay, hopefully, they do and you get out, you get paroled and do well but that's gonna be up to the parole board. So you gotta do everything you can to basically get in their good graces. So do all the classes you can and kind of stay on top of your stuff out there, okay?
Okay, thank you. Thank you.
Mr. Hicks, good luck.
Next one is on top of page 121, Judge. Annex, may we have Robert Trevino?
Mr. Huffman, this one yours also?
It is, Your Honor.
Give me 1 second, Marisa, sorry, I've been taking these off.
In cause number 2022-0D04447, State of Texas versus Robert Trevino. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Rick Huffman, on behalf of Mr. Trevino, we are ready.
Mr. Trevino, let me ask you, are you willing to waive your presence at an in-court hearing on this matter? Or would you prefer to go ahead and resume in this teleconference/Zoom hearing that we're doing right now? Here, let me simplify the question. I made it complex. Are you okay that we're not meeting in person?
Yes, yes.
Okay, so we can resume on Zoom.
Yes, ma'am.
All right, let me go ahead and have you raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth, Mr. Trevino.
Yes, ma'am.
All right, you may lower your hand. If you'll go ahead and state your name, date of birth, and whether or not you are a U.S. citizen.
Robert Trevino, 9782, and yes, I'm a U.S. citizen.
All right, Mr. Trevino, know that as you stand there, you are looking at a plea in a state jail of 1244A, punishment not to exceed 1 year in the county jail and a fine not to exceed $4,000. Do you understand these charges?
Yes, ma'am.
All right. You understand you have a right to remain silent, a right to trial by jury, a right to counsel, a right to confront or cross-examine witnesses, and right to call witnesses on your behalf or in your defense.
Yes, ma'am.
All right. Mr. Huffman, have you had more than 10 days to prepare for the defense of this case?
Yes, Your Honor.
All right. And Mr. Trevino, I have before me what's been marked as State's Exhibit 1, which is the plea packet. Is this your signature on these papers?
Yes, ma'am.
Did you read and understand the plea papers?
Yes, ma'am.
All right, Mr. Huffman, did you explain the plea papers to your client, and do you believe he has understood the admonishments, the rights and consequences of giving up these rights by entering a plea into this case?
Yes, Judge, we reviewed the plea papers at the annex, and I do believe he understands his rights and his waiver of rights.
All right, Mr. Trevino, are you satisfied with your attorney's representation of you in this case?
Yes, ma'am.
Mr. Huffman, do you have any reason to believe your client is not presently competent to enter into this plea?
No, Your Honor.
And Mr. Trevino, have you ever been found incompetent by any court or examined by a doctor or psychiatrist who has found you to be mentally ill?
I do have seizures. I am diagnosed with epileptic seizures, if that's what you mean.
Okay, has anybody said you were mentally ill? Seizures are more of a physical condition that stems from the brain, but are you determined to be mentally ill? I don't want to give you examples of mental illness, but I just need to know, has anyone ever
Like depression, like that sort of thing.
right, depression, paranoia, bipolar? I don't want to continue. Has anybody found you to be incompetent?
No, ma'am.
Huh?
No, ma'am.
No. Okay. You understand what's going on here, correct?
Yes, ma'am.
Okay, and you understand that I'm the judge?
Yes, ma'am.
Okay, and what am I supposed to be doing here as the judge?
Sending me to see whether I was gonna get time or time reserved, time served.
And who is your attorney here today?
Mr. Huffman.
All right, and do you know that I have a state prosecutor on the camera? Do you understand what she's supposed to be doing here today?
Yes, ma'am.
What is she supposed to be doing?
Basically prosecuting me.
Okay, and are you aware of enough that you want to go forward with this hearing?
Yes, ma'am.
All right, so based on your representation, your testimony, your attorney's representation, and my observation, the court finds that you are competent to enter into this plea. You stated you are a U.S. citizen earlier, and I need to know you to know that I do believe you, but in case there's some reason that you are not, a plea of guilty and a finding of guilt may result in deportation, the exclusion from admission to this country, or the denial of naturalization. Do you understand that, Mr. Trevino? All right. To the charge against you, what is your plea?
Guilty.
I'm sorry, I could not hear you.
Guilty.
All right. And are you making this plea freely and voluntarily?
I'm making, I am guilty of the charge.
You're guilty of the charge. Is that what you responded back with?
Yes, ma'am.
All right. So I'm going to go ahead and find that this plea is freely and voluntarily. Let me go ahead and ask the state to please summarize the evidence.
Yes, Judge, had the state proceeded to trial, the state would have been able to prove beyond a reasonable doubt that on or about the 20th day of February 2022, in the county of El Paso and state of Texas, Robert Israel Trevino, hereinafter referred to as defendant, did then and there intentionally or knowingly possess a controlled substance, namely methamphetamine, having an aggregate weight, including adulterants or dilutants in the amount of 1 gram or more, but less than 4 grams. At this point, we would ask the court to introduce into the record State's Exhibit 1 and State's Exhibit 2.
No objection from the defense, Your Honor.
All right. Said documents are admitted into evidence. Ms. Elizalde, is there a recommendation as to this case?
Yes, Judge, our recommendation is to reduce the charge, lesser included offense to the state jail felony pursuant to 12.44A, and we are asking for 120 days.
Okay, and there is a dismissal also?
Yes, but that is a misdemeanor dismissal, Mr. Huffman, not to the misdemeanor ADA, or I can after the.
Yeah.
I can still sign that, but if you'll, oh, but Marisa can't take it. Go ahead and send it to the misdemeanor court. Okay, Mr. Huffman, is this your understanding of the plea agreement?
Yes, it is, Your Honor.
And have you had a chance to review portal and all documents tendered to you?
Yes, Judge.
Mr. Trevino, is this your understanding of the plea agreement in this case?
Yes, ma'am.
Right. Mr. Trevino, understand the plea agreement is not binding on the court. However, should I reject it, I would permit you to withdraw your plea of guilty. If the court follows the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. These are the appeal rights explained in the trial court certification of your right to appeal. The original of which is signed by you, your attorney, and Judge Bettis, and by me, and a copy will be given to you at a later time. Based on your plea of guilty and the evidence introduced, I will accept your plea at this time and find the evidence substantiates your guilt. I'm going to go ahead and find you guilty of the lesser included possession of controlled substance penalty group 1 under 1 gram to be punished as a 1244A. I will assess your punishment at 120 days in confinement in the El Paso County Detention Facility. The sentence will commence this day and you will be given credit for any time that you have spent in jail on these charges. Have I followed the recommendation, Mr. Huffman?
Yes, Your Honor.
Right. Ms. Elizalde, have I followed the recommendation?
You have, Your Honor.
Anything further, Mr. Huffman?
No, Your Honor.
Anything further, Ms. Elizalde?
No, Your Honor.
All right, Mr. Trevino, you'll go ahead and be fingerprinted in just a little bit and they'll give you copies of some of your paperwork, okay? I'm showing you have approximately 79 days in jail, okay? Good luck. We are adjourned on this matter.
Staying on page 21, Judge. Annex, may we have Ulloa?
Ulloa,
Yes, sir.
coming up. No. Okay.
In cause number 2023-0D00178, State of Texas versus Alexander Ruben Ulloa. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Rick Huffman on behalf of Mr. Ulloa, we are ready.
All right, I'm showing that this is set for a bond hearing today, correct?
That is correct, Your Honor.
All right, Mr. Huffman, I'm assuming obviously that it is your motion, so I'll let you go first.
Thank you, Judge. Your Honor, Mr. Ulloa is currently in custody on this case, an alleged assault with the previous conviction. His bond is currently set at $50,000 on this case. He also has an unfiled burglary of habitation and he has a misdemeanor evading arrest. Your Honor, he was out on bond on the burglary of habitation when he picked up this offense. It's my understanding that he was reporting to the PR bond office and complying with the condition. Your Honor, the burglary of habitation is over a year old and it still has not been indicted. He was basically arrested for that burglary sometime, I think in July of last year, and immediately released on PR bond on that case. And I think that I don't have the report in front of me, but I think that's because that case is, well, I don't think it's likely that case gets indicted. I guess let me just put it like that. And I could go into the facts of that case if the court kind of wants to know a little more about that one. Judge, on this case, it seems, at least from what I have so far, it seems like a he said, she said type case. There's no video, no audio, no pictures, no written statements. At least from what I've been given so far in portal. Your Honor, Mr. Uroa he's not working right now, Judge. He just recently got approved for disability, and Judge, that's because there are a lot of health issues. Mr. Uroa is basically paralyzed on the left side of his whole body. He also suffers from seizures, anxiety, and depression. He was on medication for basically all of that stuff outside of jail. But since he's been in custody, he's only been given medication for his seizures. He's had 2 seizures while in custody, Judge, and he's been taken to the hospital once. It seems like that he's not being cared for properly in the jail, and I've got some concerns for his overall health in the county jail. Mr. Ulloa is a United States citizen. He's lived in El Paso his entire life. Judge, he has a number of places that he can stay. He was living with the complaining witness, Judge, at the listed address, and it's unclear if she's still there or if she's moved. However, and that's basically a house that's in Mr. Ulloa's family. It's like I think it was his grandma's house. He doesn't mind her staying there. He has other places he can live. He has his grandmother's house and he has his sister's house. I've spoken to his sister and she's confirmed that. He and the complaining witness have no children.
Say that again. Whose house? I heard grandma's, but who was the first house?
Sisters.
Sister and grandma?
Correct, Judge. He's lived in El Paso his whole life. He has a lot of people out there that he can stay with.
What
Those
is there a
two
mother?
are
Is there a mother in this scenario, or is she?
There is, Judge. And I imagine he could stay there, but I did speak to the sister, and the sister said, definitely my house, definitely grandma's house. So I kind of stopped there. I didn't reach out to mom and ask mom if he could stay at her house.
All right. Thank you for answering my question. You may proceed.
Okay, Judge. Your Honor, as I was saying, Judge, he doesn't have any children with the complaining witness. He doesn't have any reason to contact her. He doesn't want to contact her. So he is completely okay with an order of no contact. He promises to comply with any conditions the court puts on his bond. He promises to attend court. Your Honor, obviously, I don't think the court can touch the burglary, the alleged burglary case, Your Honor, but we would ask the court to reduce the assault case to a PR bond, Your Honor, or something that is reasonable that the family might be able to afford.
All right. Let me go ahead and hear from Ms. Elizalde. Go ahead, Ms. Elizalde.
Thank you, Judge. Judge, the state would object to any bond reduction in this matter. If you could stay with me briefly, Judge. The facts are very concerning in this case. Officers were dispatched in reference to domestic disturbance. As officers get there, they have the victim running out from the front yard, screaming for help. CW stated she was scared for her life because the defendant was mentally unstable and had just assaulted her. CW said she came home, the defendant started yelling at her, grabbed her from her vehicle and threw her on the sidewalk. The defendant told her to leave and that he didn't want her there. The victim ran into her room. The defendant grabbed her and pushed her down on the ground. The defendant got on top of her, held her down for approximately 20 seconds or more, preventing her from moving or escaping, which is the unlawful restraint that got declined for extraneous. The CW had visible injuries, a fresh 2-inch laceration on her right hand, and a small amount of blood on it, consistent with her version of events. When officers were there, the defendant was also at his house. The defendant was aggressive with officers. He removed his t-shirt and assumed a fighting stance. He asked the officers if they wanted to fight. He then ran back inside the residence and came back to yell that he had a gun.
All right, Ms. Elizalde, I missed that. You asked the officer something and then you cut out.
He asked the officers if he wanted to fight. He then ran back inside the residence and came back to yell that he had a gun. Officers did not observe the gun. Defendant told officers over the phone that he would not come out until he got what he requested. When asked what that was, he said a 6-pack of beers. He picked up and evading the next day. There's a note from officers saying offender is known to have violent tendencies due to prior contact with officers. Officer Prada has before observed a video cell phone recording of the offender holding a large kitchen knife and stating that he was going to kill the police. This is on 11/22/2022.
And I'm sorry, Judge.
Go ahead, Mr. Huffman.
I haven't seen the picture that Ms. Elizalde is referring to. His criminal history is very limited, Judge.
It's very what? I couldn't hear you. I'm sorry, I couldn't hear you. It's very what?
His criminal history is very limited. I think the worst of it was a burglary of building 1244A that he got 60 days on. I think that's I think that was like in 2006 or something. I think that's the worst of his criminal history. So you know, just to respond. That's all I got.
I have priors. Some were dismissed, some were convicted. Of the building. Go ahead, Ms. Elizalde. What were you gonna say?
I do have a summary of his history and one more point I want to add. So he has a terroristic threat that was in 2000, that was dismissed, that was in juvenile. Burglary of a building in 2000, that was a conviction. Harassment in 2006, and probation was revoked in 2007. Burglary of a building in 2007 with 60 days. Most concerning, an assault family violence in 2007, and a DWI in 2016. And I will say, Judge, we've had contact with the victim, very important, and I want to alert the court to this.
Go ahead.
There is a protective order in place and a no contact already as bond. And the defendant has called our victim from jail. So we are saying here today that he is not going to contact her, that he's okay with a no contact, but he has been calling her from jail. The defendant has told CW that he would kill her mother. Needless to say, I have requested jail calls. Mr. Huffman, you said there are no photos, no video. Yes, there are. I just need to get them uploaded. They have been requested. You will be getting a body worn camera, video, 911 call, and photographs, including officer history. So that's all going to be uploaded. I have concerns based on the record, the facts, and his conduct recently.
Let me ask you. Somewhere there was a notation that he was on PR bond, correct?
He was, Judge. For the burglary of habitation, he was basically he was arrested in July, I believe. The alleged offense was, I think, in November, but he was arrested in July and basically immediately released on PR bond on that case. And I believe he's been doing well on PR bond.
I don't know if Ms. Pineda has that information. Ms. Pineda, do you happen to know how he was on PR bond?
I do not, Your Honor.
All right.
Judge, if I could respond to that, I guess the most serious allegation, the most serious conviction was that 2007 AFV. It was basically a fight with his stepdad. You know, I don't know the details, but I don't think there were any visible injuries in that case, according to the report. But you know, that's what that was.
Well, we also have the DWI, which was originally charged as with a child passenger, a child under 15, and that was reduced to a lesser. That was originally in the 409. But for some reason, I have the belief that when he was on PR bond, he did not report for over 3 months, Mr. Huffman. And so if you need to verify that with your client, you may.
Is that in the affidavit, Judge? Because
No, it
that
was-
was my understanding that PR bond got revoked because he picked up this new op-ed.
Let
Yeah.
me see if I can figure out. It was because it was a two-parter. He failed to report and he picked up the new offense.
Right. Well, Judge, I've got nothing to rebut that.
So that's my concern, is that he was already released on PR bond and he showed non-compliance, not only in not reporting, but also in picking up the new offense. I'm going to tell you that having the CW still on board with the state and asking for no contact, goes far too with the court. I'm going to tell you that as of right now, I am going to leave the bond as it is, okay? And so, it already, offers the PR supplement, the PR bond supplement. So if he does make bond, obviously no contact with CW, no new offenses, no alcohol, no controlled substances, and reporting monthly to PR bond and not to move without letting PR bond know. All right.
Understood, Your Honor.
All right. So the reasons for the denial are the safety of the CW, the previous non-compliance with the PR bond conditions, and the safety of the community. All right.
Thank you, Judge.
All right. Thank you, Ms. Elizalde. Mr. Huffman, is there anything further?
Not from the defense, Your Honor.
All right. All right. Mr. Uyola, we're concluded on this matter. Keep in touch with Mr. Huffman. He'll let you know on your next steps on what you're going to do, okay?
There, I don't know if the court can ask the jail to take him to the clinic and maybe see if there's anything that's lacking. I don't know if that's possible, Judge.
Do you want him evaluated on the MHMR?
No, more so like the paralyzation meds, the heart medication, that type stuff.
Jail, can you have him examined by the nurse, please, in the next 24, 48 hours?
Yes, ma'am.
Thank you very much. I appreciate that.
Thank you, Judge.
Thank you, Mr. Huffman.
Annex, may we have Villa, Aaron Villa?
Yeah.
Mr. Huffman,
Yes, ma'am.
really quick, there's a condition for forfeiture of the weapon that usually requires a motion with your defendant's signature. I know that Vance took care of this, or Javier did. Did anyone?
You know, I could have sworn we threw that in there.
Okay, maybe it is in there and I did not see it.
Which one has the forfeiture of the weapon, the
They
4240
both do.
or the 1671?
They should both have it, Your Honor.
I'm not seeing it in 4240. Give me a second.
Is there any way we could do like an oral motion, Judge? Because I for some reason I mean, I've got it here. Did I not?
Mr. Maruco, do you have the motion to forfeit the weapon? The only reason why it's got to be in written is because it's sent to the evidence custodian, Mr. Huffman, so that they can go ahead and dispose or take care of the weapon in the manner that it's scheduled to be taken care of, whether it's forfeited or destroyed.
I understand, Judge. I'm looking for my sent email on Mr. Villa. could have sworn we did it, Judge, but I will make sure. I mean, can we still move forward with the plea or would the court rather wait for that motion? Or I guess Ms. Elizalde.
Well, this is the thing. He's going to TDC. I'm not showing that he has enough credit, so I do believe he's going to be in the jail for a little bit longer till he's transported. What I can do is go ahead and set it for a plea, and then we can follow up in a week for you to provide that document.
I'm not seeing it on my end, Judge, but I'll go through my.
Yeah, I'm not seeing it in my paperwork right now, Mr. Huffman.
If you don't have it, just send me an email and I'll do it again.
You know what? I have the paperwork that Mr. Salcedo sent me, but I didn't. I guess I didn't get that. I didn't print that out, but I apologize. I'll get that done.
Sorry, Judge, for clarification, this will get reset?
No, we're gonna go ahead and take the plea.
Okay.
And Mr. Huffman will have 1 week to get you that paperwork to forfeit it.
Okay, Judge.
So it's not gonna be a reset of the plea. We'll just set it for a status in 1 week. So Mr. Huffman can provide with the paperwork. Mr. Villa should still be in custody. I can't believe the transport would occur that fast. Jail, would the transport to TDC occur within a week?
I'm sorry, ma'am?
Would a transport to TDC occur within a week?
Now you're under. No, ma'am.
Okay, I didn't think so. All right, so.
A month.
Yeah,
Or so.
okay, he's got time. All right, Huffman, you got to get us that in a week, but let's go ahead and take the plea today.
In cause number 2022-0D04240 and 2022-0D01671, State of Texas versus Aaron Joseph Villa. Announcement at council, please.
Eliana Elizalde for the state. State is ready.
And Rick Huffman, on behalf of Mr. Villa, we are ready.
All right. Mr. Villa, before I swear you in, let me ask you, are you willing to waive an in-person hearing? In other words, are you okay proceeding on this teleconference / Zoom?
Yes, Your Honor.
All right, so we are going to go ahead and proceed. Please raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
All right, you may lower your hand. Mr. Villa, please state your full name, date of birth, and whether or not you are a U.S. citizen for the record.
My name is Aaron Joseph Villa. I was born September 14, 1998, and yes, I am a U.S. citizen.
All right. Mr. Villa, you are currently charged with under 4240, that cause number is 2nd degree unlawful carrying of a weapon with a felony conviction, and under 1671 unlawful possession of a firearm by a felony, a 3rd degree. They are punishable by no less than 2 years and no more than 10 on the 3rd degree and no more than 20 on the 2nd degree. Do you understand these charges?
Yes, Your Honor.
All right. Do you understand you have the right to remain silent, a right to trial by jury, a right to counsel, a right to confront or cross-examine witnesses, and a right to call witnesses on your behalf or in your defense? Do you understand these rights?
Yes, Your Honor.
All right. Mr. Huffman, have you had more than 10 days to prepare for the defense in this case?
Yes, Your Honor.
All right. And Mr. Villa, I have what's been marked as States Exhibit 1, which are the plea packets in the said cause numbers. Are these your signatures in the plea papers?
Yes, Your Honor.
Did you read and understand the plea papers?
Yes, Your Honor.
All right. Mr. Huffman, did you explain the plea papers to your client, and do you believe he has understood the admonishments, the rights and consequences of giving up these rights by entering a plea in this case?
Yes, I did, and yes, I do, Your Honor.
Mr. Villa, are you satisfied with your attorney's representation of you in this case?
Yes, Your Honor.
Do you have any reason to believe your client is not presently competent to enter the plea, Mr. Huffman?
No, I don't, Your Honor.
Mr. Villa, have you ever been found incompetent by a court or examined by a doctor or psychiatrist who has found you to be mentally ill?
No, Your Honor.
Okay. Based on your testimony, your attorney's representation, and my observations, I find that you are competent to enter into this plea. You previously stated you are a U.S. citizen, and while I do believe you, I need you to know that if for some reason you are not, that a plea of guilty and a finding of guilt may result in the deportation, the exclusion from admission to this country, or the denial of naturalization. Do you understand that?
Yes, Your Honor.
All right. To the charge against you, the 3rd degree and the 2nd degree, what is your plea?
Guilty, Your Honor.
All right, and are you making this plea freely and voluntarily?
Yes, Your Honor, I'm positive.
All right, no problem. Ms. Elizalde, please summarize the evidence.
Thank you, Judge. As to cause number ending in 4240, had the state proceeded to trial, the state would have been able to prove beyond a reasonable doubt that on or about the 4th day of October 2022, and anterior to the presentment of this indictment in County of El Paso and State of Texas, Aaron Joseph Villa, hereinafter referred to as defendant, did then and there intentionally, knowingly, and recklessly carry a handgun on or about his own person, and the defendant was not on the defendant's own premises or premises that were under the defendant's own control, and the defendant was not inside of it or directly en route to a motor vehicle or watercraft that was owned by the defendant or under the defendant's control, and the defendant was prohibited from possessing a firearm under section 46.04A of the Texas Penal Code, in that at the time of the commission of the charged offense, the defendant had been previously convicted of the felony offense of assault family household member, previous conviction IAT on the 5th day of January 2018, and cause number 2017-0D00055 in the 346th District Court of El Paso County, Texas, and the defendant's possession of the firearm occurred before the 5th anniversary of the defendant's release from confinement or from supervision under parole or from supervision under mandatory supervision following the conviction of the felony. And it is further presented that prior to the commission of the charged offense on the 5th day of January 2018 in cause number 2017-0D02801 in the 346th District Court of El Paso, Texas, the defendant was finally convicted of the felony offense of aggravated robbery. At this point, the state would ask the court to admit into the record State's Exhibit 1, plea papers, and State's Exhibit 2, disclosure forms.
No
All right.
objection from the defense, Your Honor.
No objection to the admission on both cause numbers?
Under both cause numbers, Your Honor.
All right, the plea packets are admitted in both cause numbers. Is there a plea bargain agreement, Ms. Elizalde?
Yes, Your Honor, 2 years confinement in the Texas Department of Criminal Justice with no period of community supervision and a forfeiture of the weapon to be completed in a week.
Okay. Mr. Huffman, is this your understanding of the plea agreement?
Yes, it is, Your Honor.
And have you had a chance to review portal and all documents tendered to you?
Yes, Your Honor.
All right. Mr. Villa, is this your understanding of the plea agreement in this case?
Yes, Your Honor.
All right. Mr. Villa, understand that the plea agreement is not binding on the court. However, should I reject it, I would permit you to withdraw your plea of guilty. If the court follows the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. These are the appeal rights explained in the trial court certification of your right to appeal, the original, which is signed by you, your lawyer, and by Judge Bettis, and a copy will be given to you at a later time. Based on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I find you guilty of the 2 offenses, in 4240, the 2nd degree unlawful carrying of a weapon with a felony conviction, and in 1671, the 3rd degree offense of unlawful possession of a firearm by a felon. I assess your punishment at 2 years in the institutional division of the Texas Department of Criminal Justice. Your sentence will commence this day and you will be given credit for any time that you have spent in jail on these charges. Mr. Huffman, have I followed the plea agreement?
Yes, Your Honor.
Ms. Elizalde, have I followed the plea agreement?
You have, Your Honor, but I did want to note for the record that I did not summarize the facts and evidence in cause number 1671.
Okay. Mr. Huffman, let me go ahead and have her summarize 1671.
Yes, Your Honor.
Your Honor, had the state gone to trial, the state would have been able to prove beyond reasonable doubt that on or about the 5th day of May 5th, 2022, and anterior to the presentment of this indictment in the County of El Paso and State of Texas, Aaron Joseph Villa, hereinafter referred to as the defendant, did then and there, having been convicted of a felony offense of assault family household member with previous conviction on the 5th day of January 2018 in cause number 2017-0D00055, in the 346th District Court of El Paso County, Texas, intentionally or knowingly possess a firearm before the 5th anniversary of the defendant's release from confinement following the conviction of said felony. And it is further presented that prior to the commission of the charge offense on the 5th day of January 2018 in cause number 2017-0D0-2801 in the 346th District Court of El Paso County, Texas, the defendant was finally convicted of the felony offense of aggravated robbery.
Mr. Huffman, any objections to that summarization?
No, Your Honor.
All right, and all documents had been previously admitted. Is there anything further, Ms. Elizalde?
No, thank you, Your Honor.
All right, anything further
Okay.
from Mr. Huffman?
Yeah, yes, Judge, excuse me. Your Honor, if I may inquire into the credit, these were two separate incidents. So I was just wondering if I could get a count on how much credit he has on each case. Just to, if that's okay, Judge.
I understand, Mr. Huffman. Let me say this. For right now, I'm showing 91 days in jail on both. That's what I'm showing. Ms. Catherine Martinez will figure that out late and give me an accurate count later. Ms. Martinez, are you showing anything right now? Or Marisa?
Judge, I have 107 days.
107. Okay. On both, Ms. Martinez?
That is correct, Judge.
All right. 107, Mr. Huffman, as of today.
I appreciate that, Your Honor.
No problem. All right, Mr. Villa, there is going to be a document brought to you by Mr. Huffman. It is the 415 or destruction of the weapon. It was already part of this plea agreement. You do need to sign it, okay? And if you don't, we'll have a hearing on that, okay? But you can make it easy by going ahead and signing because it was part of this plea agreement. It's something that you've already agreed to, okay?
Yes, Your Honor.
All right, they're gonna go ahead and fingerprint you, and then you'll be given credit, as I stated before, for all time that you've served on this case. Good luck to you, Mr. Villa.
Thank you, Your Honor.
Take care.
And Judge, I'm headed to the annex tomorrow, so I'll have it to the court tomorrow, Judge.
Okay, and if you, though they won't set it for